This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
So let's assume that you lose your reliability challenge under Daubert if you're a defense attorney, and this digital evidence or this DNA evidence or whatever it is coming in at trial. That doesn't mean that you've lost the case or lost the ability to contest the accuracy of the evidence. It's just that now you have to do it through confronting the evidence at trial. Now, in the United States, the right of confrontation is a constitutional right in the Sixth Amendment. In all prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. Generally, that has been interpreted as meaning you have the right to cross-examination at trial. You have the right to physical confrontation, looking the person in the eye, and the right to place them under oath. And so the only way that you can get those things is through live testimony of the witness. This same concept, this preference that the Anglo-American system has for live testimony is also, you can also see it in the rule against hearsay. This is not a constitutional rule, this is a rule of evidence. Every jurisdiction has it. I think the United Kingdom has gotten rid of the hearsay rule in civil cases. We're basically the only system in the world that still loves the hearsay rule. Has to be brought in through live testimony. You can't bring it in through an affidavit or a certified statement or a rumor. And that applies to expert testimony as well. Essentially, in either a civil or a criminal case, we start with the presumption that a person's assertion about anything, if it's being brought in to prove the truth of that assertion, has to be brought in through live testimony. You can't bring it in through an affidavit or a certified statement or a rumor. And that applies to expert testimony as well. By the way, I hope it's very clear that when I was talking about Brennan Mayfield, I was suggesting with respect to his religion and the fact that he hadn't left the country, I was suggesting that the authorities were infected with confirmation bias in assuming that those details were anything other than completely innocuous. Okay, so this is great for a human digital expert like John was cross-examining at that great hearing. You can put them on the witness stand and cross-examine them. But with respect to a machine, you can't cross-examine most machines. You can't physically confront them or put them under oath. Machines can certainly be deceptive, but we don't think of them as being having souls or wanting to be insincere. So what does confrontation mean when it comes to machine evidence? And it's a very difficult issue that the US hasn't really figured out yet. But let's just think of it in the same way that we thought of those black box studies. Yeah, you can't physically confront a machine, but you can get inside of it and try to think about what could go wrong with it. You could require independent software testing. You could find out what the machine has said about the same subject matter before and see if the machine has made inconsistent statements. You could look at the source code if it's software and see if there's something wrong in the way that it is implementing a method. You can see if it fails to take into account key variables. You can look at validation studies. So there are different ways that we can think about showing errors that come from machines. But the reason that we can't just use the hearsay rule and say, oh, you can't bring in that software output, it's hearsay, is because the hearsay rule only applies to humans. So it wouldn't make sense to just keep out all machine evidence because we think we want to treat it like hearsay. So let me give you one example of a high-profile machine error in the DNA context. So there's new types of software that analyze DNA mixtures that are very hard for human analysts to figure out, basically impossible, because you have to go through hundreds of thousands of permutations to think about what the chances of seeing this evidence, assuming that the defendant is a contributor to this mixture versus assuming that the defendant is not a contributor. And so this software looks at the mixture, and then it reports something called a likelihood ratio, which is just a statistic. And so one of these software programs is called TrueAllele. Here's Mark Perlin, the person who invented TrueAllele. There's a competing program called StarMix from New Zealand. This is John Buckleton, who created StarMix. These are competitor companies, and they say very bad things about each other, and they sue each other and all of this. And so this is the sort of thing you would see in a real case. You know, a match between the beer bottle and the suspect is, you know, gazillions of times more probable than a coincidental match to an unrelated Black person. So to a jury, that sounds very damning, to say the least. So let me show you an example. There's a tragic case in New York a couple of years ago involving a 12-year-old boy who was strangled, and they didn't have a suspect. There was no physical evidence linking anyone to the crime. There was one person who was involved in a domestic dispute with the boy's mother, but he had what they saw as a credible alibi. Suspicion fell upon this man, Oral Hillary, who was a soccer coach and also had been an ex-boyfriend of the mother. He claimed he had nothing to do with it. There was no physical evidence linking him to the crime. But then police found a tiny bit of DNA, a DNA mixture underneath the boy's fingernail. Such a tiny little bit that it was a very complex mixture. By a DNA mixture, I mean a sample of DNA that you might find at a crime scene that has more than one person's DNA in it. So sometimes you can look at some blood or some other bodily fluid, some skin cells, and do a DNA analysis and realize it's only one person's DNA. There's only one person's genetic markers in there. And other times you can see that there's a lot of stuff in there. It's more like a soup. And you don't know how many people are in there sometimes, but you realize that it's a mixture. And so this is where the software can really help, because mixtures are very hard to interpret in terms of who might have contributed to this, how many people are in it, all of that. So the prosecution sent this mixture to TrueAllele and said, can you help us out? And TrueAllele said yes. And it returned a report saying, we conclude that Oral Hillary is not a contributor to the mixture. So the case went cold. A new prosecutor was appointed, was elected, and sent it to StarMix, the competing program. And StarMix said, yes, he is definitely a contributor. Had a very high likelihood ratio suggesting that he was definitely a contributor. So you have two highly sophisticated software programs, both of which were deemed decently reliable in validation studies, or at least developmental validation studies, but they both came to diametrically opposed results in a case involving the exact same DNA sample. Let me give you one more example, and then I think John and I were going to talk about the future. So far we've talked about software. We're talking about a maximum of, say, 200,000 lines of code. It's very sophisticated, but you could look at the source code. But we are on the cusp of evidence that is truly deep neural networks, a level of machine learning. I mean, looking at the type of deep fakes that John was talking about that are well beyond what the programmer envisioned. And I'll give you one more fun example. One of these phrases was written by William Shakespeare, and the other phrase was written by a computer. So the first one is, "What's in the brain that ink may character, which hath not figured to thee, my true spirit?" And the second one is, "King of hell, no quarrel have I left thee, no lovely maid who gleamed in fields or skies." Which one do you think is the computer? 1 or 2? 2 was written by a computer. The first is William Shakespeare. The point of this example is, in order to truly confront machine evidence, it's not enough to just have the programmer on the witness stand to cross-examine. You've really got to get under the hood and understand what the computer is doing. And the more sophisticated AI gets, the more it will be almost impossible to truly understand how the machine has gotten to the expert opinion that it's giving. So it may be that in the United States and I guess the world, we need to think of new ways to deal with this sort of evidence, deep neural networks and such. One thought is something called reversibility, that there are certain systems that can essentially be trained to be their own adversary, to try to reverse engineer their programs and to look for flaws and to scrutinize themselves. I think that will be important if we admit this type of evidence. We could just refuse to admit it, especially with respect to lie detection, on grounds that it violates the dignity and integrity of the process. But we're really on the cusp of something that eclipses the ability to truly to achieve some meaningful level of explainability when it comes to why they got the answer that they got.
I would have said this: technology is not the friend we needed. Technology is turning to the foe we didn't know we had. I think it's going to continue to be a lot of evidence that's generated. I think we're going to continue to have problems with authenticity. And I think all of us around the world are going to have to continue to educate our brethren about the limitations of digital.
So on the Mayfield case and also on the mixed DNA, I think many people around the world, including legal experts, who are trying to find new ways to determine the truth, where the truth is critically important, say in the case of a terrorist bombing or harming of a child, the law enforcement's under tremendous pressure to solve those cases. And the lure of a technological solution is just very difficult to overcome. And so here you have a computer system, in the case of Mayfield, that purports to do something a human can't do, to go through thousands or tens of thousands of known fingerprints and come up with an answer that would be very difficult for a human to do. It turns out made a serious mistake. And then same thing with the DNA. While DNA is a great tool, this small sample of mixed DNA mixtures, we haven't cracked the code in a way that's truly, that science has a consensus opinion on. But the idea that you could have this machine or this algorithm give you the answer is so attractive, it's hard to resist. Is technology a friend or a foe? it's a neutral tool, but we can't invest it with too much problem-solving ability without fully understanding it. If I'm understanding both of your presentations, and proceed with caution, I think is the moral of the story. And I think this is particularly true in China, and there are other outside the United States, certainly in Asia. People live lives relying on technology even to a greater extent than we do, using their phones to make purchases, to engage in all communications. Technology is much more part of everyday life. So I think these cautionary tales are really important.
We just need a culture of openness and a desire to quantify uncertainty and embrace uncertainty. But I'm certainly happy that we, have these tools, and we just need to not be afraid to recognize their limitations.